because I was made dead.
Yes on 8.
Yes on 8. Yes on 8. Yes on 8. Yes on 8. Yes on 8.
Of words, for instance, in one case, I think the initiative had 22,000 words, and the Constitution at that time had 50,000 plus words. I presume that you would readily agree that in the spirit do not suffer of our state constitution, nor do they affect the basic structure of government in California. Let's deal with the qualitative part of the revision test. What is the test that this court, over a number of decades, has established in determining whether or not a qualitative test is that part of the revision test is met?
The court looks at whether a measure changes the structure of the Constitution or the basic framework of our government. And that is exactly what Proposition 8 does. Our government is based on the principle not just of majority rule, but equally so on the limit that majorities must always respect minority rights. That balance between majority rule and minority rights is recognized across the world as the genius, is defining hallmark of our democratic system. That check on the power of the majority is every bit just as essential to our democracy as the principle of majority rule.
Counsel, our case has been limited to changes in government structure, ceding judicial power to the U.S. Supreme Court, or changing methods of taxation. Have there been any cases that, in this amendment revision context, that focus on the diminution or elimination of personal rights? Is that necessarily precluded by our case law that deals with government structure, government planning?
No, not at all. I mean, I would note that in Raven, one aspect of the court's holding was the diminution of a significant number of rights for criminal defendants. And in Livermore versus Wade, the courts established the defining framework and held, and it's still good law, that an amendment it cannot change the core underlying principles of our Constitution. But I do want to stress that in petitioner's view, Proposition 8 does change the foundational powers of the branches.
Can you distinguish the case of giving the right to marriage to same-sex couples? And let's just say at the next election, opponents of gay marriage succeeded in placing an initiative on the ballot to reverse what the first initiative had done. Is it your position that the first initiative extending the right of marriage to same-sex couples could properly be effectuated by way of an amendment, but that this very same subject matter, by way of a repeal 2 years later, would, because it removes rights, have to be effected by way of revision rather than amendment?
Yes, but not because of the subject matter. Because the test under Article 18 is, does a measure change the structure of our government?
But are you saying it's a one-way street when you say yes, that you can extend rights by way of amendment, you can take them away only by way of revision, the same rights?
No, I'm suggesting that is not under this court's jurisprudence, the appropriate legal test. That what the court has to be looking at in determining whether a measure is an amendment or revision, does it change the very nature of our basic government? Does it change the structure and purposes of our Constitution? It's perfectly consistent with our existing Constitution for the people to decide to extend rights, to create new rights, to expand or limit the scope of existing rights. That in itself does not change the structure of our government or the relationship between majorities and the Equal Protection Clause and the court's judicial role in enforcing equal protection. But because the very nature of equal protection, its primary purpose is to protect historically disadvantaged minorities, for a mere majority to be able to remove a suspect class from the protection of equal protection, the equal protection requirement, disables both the equal protection guarantee itself and materially it defeats the court's ability to play its role, its core constitutional role in enforcing equal protection. That is not true when majorities simply alter or change the substantive scope of a fundamental right. Equal protection in this context should not be understood just as a particular discrete right. It is an animating requirement that pervades the whole Constitution and pervades the enforcement of every other fundamental right in our Constitution.
Did I understand you to say that an amendment could change the substantive scope of equal protection right?
Yes.
Well, then why, in this case, is not the mere removal of the privilege of nomenclature of marriage just alter the substantive scope of a fundamental right which remains in place?
Because it's not, the nomenclature is not the point. The point is the equality requirement. This court held in the marriage cases that it may or may not be required by the fundamental right to marry to provide the word marriage to everyone. But that what is indisputably, essentially required is that the same term and status be applied equally to preserve that essential integral requirement of the fundamental right to marry that's part of every fundamental right, that by definition it has to apply equally to all persons.
Would this court have the authority, in your view, to say, based on the principles that you're espousing, that everybody that's married by the state is going to have a civil union and none of it can be called marriage, and if you want your union to be called marriage, you can go to a place of faith where they have the sacrament?
That would not run afoul of the limits and principle that the petitioners have put forward to this court. The core of our argument is that a simple majority cannot be permitted to take away rights from a historically disadvantaged minority without thereby substantially altering the very operation and purpose